Thank you, Honourable Deputy Speaker. I wish to second the motion presented by the Chief Opposition Whip on the historic motion that has been placed before the House. I say historic because this is a first occasion in the history of this country that a motion of no confidence has even been placed and is being debated for two days. It's not a happy occasion when we have to support a motion of no confidence on the Speaker of this House, because the Speaker is the guardian of the privileges, the powers accorded to Parliament, its members, and unfortunately it has become necessary to place before this House and the country and the whole world that the Speaker has breached that confidence that was placed on him when he was elected as Speaker of this House. It is also the first time that we see
Order please. දිවාහාර විවේකයේ සඳහා සභාවේ කටයුතු තාවකාලිකව එක දක්වාත් සිටින්න.
Honourable M.A. Sumanthiran, you can continue.
Thank you, sir. As I began my speech on this issue, I was pointing out the fact that this is the first time on many fronts that a no confidence motion of this nature is being debated in this House. Before I continue, I must disclose my interest in the matter in terms of the standing orders and the etiquette for members of Parliament. I was counsel when the matter came up in the Supreme Court for determination, and also after this purported endorsement by the Speaker of this bill called the Online Safety Bill on the 1st of February, I moved the Supreme Court by way of a fundamental rights petition. I was the petitioner seeking to rule that the Speaker's endorsement is not valid in law insofar as it is not a legislative act, that it was an administrative act by the Speaker. Nevertheless, the Supreme Court has refused to grant leave to proceed in the matter that I petitioned the Supreme Court, and uncustomarily they have actually given reasons for not granting leave to proceed, in which they have cited Article 80, Sub-Article 3, saying that the court has no jurisdiction to look into a matter where the Speaker has already endorsed the bill. Now, I want to place on record here that I do not agree with the decision of the Supreme Court in refusing to grant leave to proceed, and I am moving the Supreme Court again to review their decision, which any apex court in any country has the power to do. And having disclosed my interest in the matter, may I continue to say that this is the first time that a determination of the Supreme Court in regard to a bill has been blatantly violated by Parliament, unfortunately. And that is the reason why, primarily the reason why this no confidence motion on the Speaker has been presented. In every country, when the legislature passes a law, there is a requirement that someone either endorses it or grants his or her assent to it, and it is only upon that act that the said bill will become law. Now, why is that? Why is that requirement there in all legislatures of the world? The Queen's assent. Prior to independence, we had the requirement of the Governor General's assent. Even now in the provincial councils, we have the Governor must assent. Here the Speaker, or if there is a referendum, the President must endorse. Why is that there? And the answer to that is here in the Constitution itself. Let me read from Article 75 certain provisions in the Constitution that talk about the legislative power of Parliament. The side note itself in Article 75 says legislative power. And it says Parliament shall have power to make laws, including laws having retrospective effect, and repealing or amending any provision of the Constitution or adding any provision to the Constitution, provided, now there is a proviso, that Parliament shall not make any law suspending the operation of the Constitution or any part thereof. Now let's say this is there. There is a prohibition on Parliament suspending any part of the Constitution. But let's say there is a bill before Parliament which purports to suspend the operation of a provision in the Constitution. It's taken up for debate, it is said to be passed. And the Speaker endorses it. Now, does it become law? No, it doesn't. It doesn't. Merely because the Speaker has endorsed something that went through Parliament does not make it law. Because the Constitution specifically says you cannot suspend the operation of the Constitution or any part of the Constitution. Right? Then another prohibition, repealing the Constitution as a whole unless such law also enacts a new Constitution to replace it. You can't merely bring a bill to say the Constitution is repealed. Even if you pass it with the 2/3 majority, that won't become law. Even if the Speaker endorses on it, it doesn't become law. Then Article 77, now this is also important because the Speaker, in justifying his conduct in endorsing this bill, says, I acted on the advice of the Attorney General. Now I must say, he can listen to the advice of the Attorney General. But the law doesn't give the Attorney General the power to endorse any bill. And the Speaker is not expected to merely act exactly in the way that the Attorney General advises him. If that is the case, the law would have said the Attorney General can endorse the bill. He can listen to advice, but he is not a robo. He has to exercise his mind as to whether the proper legislative process has been followed. Now, why do I say that? Because in Article 77, the Attorney General is supposed to examine every bill, and it says it shall be the duty of the Attorney General to examine every bill. And if there is any inconsistency with any provision of the Constitution, he must say it at that point, before the bill is even gazetted. Because it is in Article 78 the next article, that the requirement to gazette the bill is there. I am saying this because when the matter came up before the Supreme Court, the Attorney General came and presented a series of amendments running into 18 pages. It took about 3 hours for him to list his so-called amendments. Now, if that is the case, why did not the Attorney General, acting under Article 77, which was his duty to do so, do that prior to the bill being gazetted? The Constitution says it is the duty of the Attorney General to examine and make this known. He did not do that. After it was gazetted, after it was read a first time in Parliament, and after 45 petitions were presented to the Supreme Court. That's also a first. That's the highest number of petitions ever that a bill has been challenged. That was the importance of this particular bill. And thereafter he comes. Now what would have happened if nobody challenged this bill? Then it would have just passed. Attorney General's 18-page amendments would not have been made. After it was challenged by 45, no less than 45 petitioners, the Attorney General comes to court. The determination says that, and presented from page 12 to page 19 of the determination, the Attorney General's suggested amendments are reproduced. At the beginning of the hearing, that was done. It says that was given to all counsel for the petitioners. So Attorney General, to start with, had not carried out his duties in terms of Article 77. Waited till it was challenged by 45 people, then came to court and said, well, these are the amendments that we are prescribing. But court went into even that, and in a determination that runs into 62 pages, the court clearly laid down what can be done and what cannot be done. Very specifically said, these clauses, and there were only 56 clauses, 34 out of the 56 clauses. The unique bill this is. 34 out of 56 clauses, the court said, is inconsistent with the Constitution and cannot be passed into law by simple majority. If those are to be passed, it must have a special majority, that is 2/3 the number of members of Parliament, including those not present. 150 votes had to be obtained if that was to become law. Now this is so clear in the determination. Now, in Article 79, the next article, this is what it says about the Speaker endorsing a bill. It says, the Speaker shall endorse on every bill passed by Parliament a certificate in the following form: this bill has been duly passed by Parliament. He must say that it has been not passed. He must say that it has been duly passed by Parliament. That word duly is not there for nothing. Only when it is duly passed can the Speaker endorse it, saying this and the name of the bill has been duly passed by Parliament. Such certificate may also state the majority by which such bill was passed. Then again a proviso. Proviso says, provided that whereby virtue of the provisions of Article 82 or Article 83 or Article 84 or Article 123(2), a special majority is required for the passing of a bill, the Speaker shall certify such bill only if, I stress, only if such bill has been passed with such special majority. So if the Supreme Court says this clause cannot be passed without a special majority, Article 79 says the Speaker can endorse it only if. And unfortunately, our Speaker does not seem to know what is meant by only if. Only if it is passed by special majority can he endorse that bill as having been duly passed. Provided further that whereby virtue of Article 83 the bill or any provision thereof requires the approval of people at a referendum, such certificate shall further state that the bill or provision shall not become law until approved by people at a referendum. Now that's not relevant here. It is after that, after Articles 75, 77 and 79, that Article 80 appears. And Article 83 says this: where a bill becomes law upon the certificate of the Speaker, only where a bill becomes law. He doesn't say that upon the certificate of the Speaker bill has become law. No. Where a bill becomes law, no court or tribunal shall inquire into, pronounce upon, or in any manner call in question the validity of such act on any ground whatsoever. Now, there was reference by the proposer of the motion about the Singapore law, the law in Singapore with regard to online safety. Let's say the Speaker went on a trip to Singapore. He found the act in Singapore. He thinks, oh, this is a very good law, we must also have it. He buys a few copies and comes here. He sits in his chamber and endorses it. And signs it. Does it become law? Does it become law? No, it doesn't. It becomes law only if it is duly passed by Parliament, and it is not duly passed by Parliament if the Supreme Court has determined that it shall have a 2/3 majority for it to be passed. And where do we find that? That's in Article 123(4). Article 123(4) gives the Supreme Court the power to determine any bill that is challenged before it. And Article 123(4) says, where any bill or the provision of any bill has been determined or is deemed to have been determined to be inconsistent with the Constitution, such bill or such provision shall not be passed, except in the manner stated in the determination of the Supreme Court. Provided that it shall be lawful for such bill to be passed after such amendment as would make the bill cease to be inconsistent with the Constitution. Now, in the determination of the Supreme Court that I am referring to, Supreme Court has said that this is inconsistent with the Constitution. It cannot be passed except by a special majority. But the Supreme Court has also gone on to say, but if these amendments are made, then it will cease to be inconsistent with the Constitution. So it was important, or it was necessary for the government to bring those amendments that were prescribed by the Supreme Court if this bill was to be passed by a simple majority. If the government decided that we are going to pass this by 2/3 majority of the whole number of members of Parliament, including those not present, then they could have gone ahead, because the Supreme Court has determined that it requires a special majority. But if it was going to be passed, as in this case, it was only passed by a simple majority. If it was going to be carried by a simple majority, then those amendments had to be brought in at committee stage. Several of those amendments prescribed by the Supreme Court were not there. Now we are required, or the government is required, to place on the table of every member of Parliament the committee stage amendments that are proposed to be made before 12 noon. This was a 2-day debate. Before 12 noon on the first day, a list of amendments were tabled. And because the list of amendments are tabled, I was able to examine those amendments along with the Supreme Court's determination, and I found that 13 recommendations by the Supreme Court, 13 amendments prescribed by the Supreme Court were not there in the list of amendments that the government was moving. When the committee stage commenced, Honorable Dayasiri Jayasekara and I raised that objection. We said these amendments are not there in the list of amendments tabled for us. There was a huge protest. So it is not as though the Speaker's attention was not drawn to this. It was drawn. There was a big protest. Most of us came down to the well of Parliament and told him, you can't do this. You're violating the Supreme Court's determination. I gave a document in writing listing those 13 points. It was given to the Speaker. And thereafter, the Assistant Secretary General of Parliament told me that the Additional Solicitor General who was present in the officials' box has assured that those will also be carried out. I accompanied the Assistant Secretary General of Parliament to the officials' box to see whether that was the case, and I was given that assurance that those also will be moved by the Minister. And so I came back and I told the Speaker that assurance is given. The Minister moved several amendments, but later when we looked at the purported act that has been endorsed by the Speaker, 9 of those were missing. Some of those are inconsequential, but certainly 6 of those are very, very important amendments. The Human Rights Commission, headed by a retired Supreme Court judge, also has issued a statement saying that the Act does not have the amendments stipulated, prescribed. It's not just recommendation. It is stipulated. And Article 123(4) says it cannot become law unless those are complied with. That statement says that. So, I'll give you some examples, clear examples. In sections 20, 29, 6, 31, 31.1, they are contained penal provisions regarding doubling of punishment in the event of a second or subsequent conviction. Now at page 42 of the determination of the Supreme Court, this is what the court held, and I quote, "A careful consideration of the penal sections of this bill shows that the courts are vested with the discretion to impose punishments as the said clauses set out minimum and maximum punishments. However, taking into consideration the theories that are applicable to imposing punishments for crimes, we are of the opinion that the punishments set out in the bill for repeat offenders are excessive, and therefore such clauses are violative of Article 12(1) of the Constitution. Hence, the said clauses should be passed by a special majority in Parliament. However, if the punishments stipulated for a second or subsequent conviction are deleted, the said inconsistency will cease, and therefore the said clauses can be passed by Parliament by a simple majority." If you read the Act that we have now, all of those clauses are there as they were in the bill. No change. No change. Doubling of the punishment in case of a second or subsequent offense. Supreme Court has very clearly said that's violative of the Constitution. You cannot pass it except by a special majority. But it was passed with a simple majority, and the Speaker has endorsed on it. I myself brought all of these 6 matters to the Speaker's attention by an email that I sent, and said, do not endorse the bill, because there are still some issues where the Supreme Court's clear determination is there that it requires 2/3 majority, this was not passed by a 2/3 majority, so don't endorse on the bill. That is why the requirement of an endorsement is there. Not for the Speaker to listen to the Attorney General and say, he advised me, so I am signing. Then we don't need a Speaker. We can have the Attorney General sit in that chair. The law has vested in the Speaker the power to endorse. When a bill, and he endorses it saying it is duly passed by Parliament. Not even just passed by Parliament. That it is duly passed by Parliament. And all of these provisions that I just read out clearly say that you cannot endorse it unless it has complied with the Supreme Court's determination. I only gave one example. There are several. Section 20 again, page 61 of the determination. Court required an amendment to an illustration in that section. And it said amend the illustrations to section 21(1) of the bill. Currently, in section 20, that illustration appears as it appeared in the bill. No amendment has been made to the illustration. Anybody who is capable of reading will know you don't need legal acumen. You don't need legal expertise. If you are able to read, if you are literate, you know what it says. I'm saddened by the fact that I have to say this in this house, questioning the very literacy of the Speaker. If he cannot read this and understand what it says, then is he capable of chairing proceedings in this house, occupying the office of Speaker? That is why we have lost confidence in the Speaker. This goes without saying. You don't have to pass a motion of no confidence. Surely the country knows that he cannot be Speaker if he can't read that. And the Supreme Court says you cannot pass it with a special majority, and it appears just as it was in the bill, in the act that he has now gone and signed. Not one, not two, not three. At least 6 such occasions, clear violations. And then how can he continue to be Speaker? The majority is not always right. And when this motion is put to vote, it will be proved that the majority is wrong. Not only is the Speaker unable to read and understand, the majority in this house also cannot read and understand. That is what you are going to prove when you vote against this motion in 2 days' time. This we are able to show. And we have led at President's Council seated in the first row. Even they will be shown up as not being able to understand simple, plain English that the determination is written in. That is what you are going to prove to the country. That you are also not literate. You did this the last time there was a no confidence motion brought against the Minister of Health. Ganged up together and defeated that bill. You ganged up together and defeated that motion of no confidence of Minister of Health. Where is he today? Where is he today? You had confidence in him? All of you together? Gloated that you have defeated the no confidence motion on him. Where is the Minister of Health today? Where is Honorable Keheli Rambukwela today? This is what will happen to the Speaker too. And you will be collaborators. You will show yourself up to the people of this country. Not just him, but every member who will vote against this motion shows himself or herself up as an illiterate person who does not understand anything, not capable of walking into the hallowed precincts of this house. If that is what you want to do, go ahead and do it. You can go ahead and do it. That's your choice. But any grade 1 student of this country will be able to tell you that you are wrong. Any child who has been taught to read will tell you that you are utterly wrong when you make that decision to vote against a motion of no confidence on the Speaker. This is not a private matter. This is not a personal issue. This involves the very honor of this house. What have we brought this house to today? A mere charade of a passage of a bill that all of us know could not have been passed. Could not have been passed. Even if we went through that charade, we know that several provisions of the Constitution that I have just read prohibit the Speaker from endorsing that bill because it was never duly passed by Parliament. So we have an illiterate Speaker and we have a bunch of illiterate members in the government side who will vote against this motion 2 days later. It's up to the country to then decide. President says this is the election year. It's up to the country to thereafter decide on every one of you who will face the constituency. You will have to answer whether you are literate or not. Secondly, by what power of imagination you thought that the Speaker was right.
Honourable Member, you have 3 minutes more.
Thank you. So, I'm asking not just the members of the government benches, I'm putting this question to the country. You wanted a system change and you are justified in doing that. The day after, when a vote is taken in this house and the government members vote to defeat this vote of no confidence, you will yet again be justified for calling for a system change. But don't say all 225 must be thrown into the Devanna Oya. One side of the house, those who vote against this motion, are the ones that must be thrown into the Devanna. They are the ones who close their eyes to what is staring them in the face and will be voting. They'll be voting with their feet. They will be voting against their own conscience. They'll be voting against any sense of reason. That's for the country. But I'm also addressing the Honourable Speaker. If you have any honour left, please resign. The proposer of the bill said how the Speaker in the British Parliament, or it was the Scottish Parliament, admitted his mistake. Admit your mistake. You don't have to be a legal expert to know what you have done. Admit your mistake, tender your resignation, and thereby guard your honour. Thank you.
Thank you.